This is LAWS13017, Civil Procedure, Week 8, Interlocutory Procedures, looking at tutorial problems 23 and 24. All right, good evening, everybody. You would have noticed I've now released the assignment marks and commentary, and I just want to make sure that well, just to remind you that the next piece of assessment is actually due quite soon. I think it's next week. So if you haven't started, now is the time to start. All right. This first problem number 23, it deals with Pedro and his Mexican restaurant and his unruly neighbour, Curl Up and Die, who's renovating their beauty parlour. And for those of you who can remember, Curl Up and Die came out of the Blues Brothers film. Anyway, the construction work continues unabated day and night. It's causing cracks in the walls of Pedro's restaurant and clouds of dust in the street. Pedro's customers are complaining about the noise and the dust, and he estimates he's lost 35% of his weekly trade. And you're asked to advise Pedro of the appropriate procedure to stop Curl Up and Die from continuing to damage his restaurant, and to limit the noise and dust to daylight hours when the dining trade is very slow. And then you're asked to draw up some documents. Okay. All right. So how do we handle this particular problem? What would we be relying on to deal with this issue? Any ideas? Any suggestions?
Well, we're going to need a court injunction that will prohibit his neighbour from causing the inconvenience, etc.
That's right.
Action.
And potentially you could go for nuisance as well, but your injunction is going to stop it immediately as soon as that's granted. A nuisance claim, you'd have to prosecute the whole thing. So that's not going to stop it until the end of the, potential trial of that issue. So certainly in the longer term, but in the short term, you really need an injunction. So remember, injunctions enable you to, or enable a court to order someone to do something or not to do something. So they go both ways. Okay, so that's a positive injunction to do something. A negative injunction is not to do something. This is an example of a negative injunction. All right, so what sort of application will we need to do that, to achieve this? So what about Rachel? I haven't heard from Rachel. Do you know, Rachel, what sort of an application we might need? Anybody can help Rachel out? He's thinking about it.
I was the one who was talking about the nuisance.
I know, but what sort of application? Oh, sorry. Haven't heard from Rachel. We have heard from Rachel.
Well, it's not a claim. So I guess it's just an application.
It's an application, yeah, but what sort of an application?
An equitable application?
No.
An interlocutory application.
It's interlocutory, that's true. Sorry, what was the other comment somebody was saying? What sort of applications can you have? You can have, interlocutory that are applications that exist within an existing cause of action. So that would be an application. And we can't have that because we don't have an existing cause of action. There's no claim. There's no statement of claim or anything been issued. So how do we get this before the court? What sort of an application? It's known as an originating application, which sort of makes sense, doesn't it? Because it's actually starting the proceeding. So it's an originating application is what's required. Okay.
I'm talking negligence here and in reference to Donoghue versus Stevenson.
Sorry, say that again. So you're talking about Donoghue and Stevenson.
Neighbour principle.
Oh, I see. Yeah, but what you're mixing up here, and it's the same issue with the nuisance. Those are causes of action, and they will result in a remedy after the end of a trial and a judgment. That's not going to help Pedro, whose restaurant is filling up with dust and his walls are cracking. That's not going to help him in the short term, because it's going to take a long time for all that process to be resolved. Now, that's something you can have as your primary claim, but in the current situation, he needs an originating application to get before the court quickly to get an injunction to prevent this, what is it, effective nuisance, I suppose, prevent this nuisance from continuing. So we're looking at a shorter term remedy rather than the longer term ones. Okay, so how quickly?
So what if we're talking about 35% of his weekly trade, what monetary value is that? We don't actually have anything to go there on that one.
Well, we don't know what his weekly trade is.
Could be $5, it could be $5,000, could be whatever.
It could be something like that, but it's damage to the building as well. So that might be much more substantial. But the point of the exercise is not so much looking at what the long-term claim will be. The point of the exercise is looking at what the shorter term remedy is. That's what we're trying to look at, the interlocutory remedy, which is an injunction, which needs an originating application to get it before the court. But how quickly can you get an originating application? How quickly can you get a return date where it's actually going to be heard in a chamber court?
Shouldn't that be about 7 days?
No, it's shorter than that. It can be, the minimum time for service, if service is required, is 3 days prior to the hearing. But you can actually get ex parte applications that don't require service, and you can get before a court very quickly, a chamber court, very quickly. A good example of that is there was an old writ called Benedicione Exponus, which is where somebody was literally had a briefcase full of money and was getting on the plane to leave the country. You can get before a chamber judge by ringing their associate and having that heard, if it's that urgent, pretty much straight away. So it can be quite quick. It just depends. Now, this one, I would have thought you don't need an ex parte application. So you'd be looking at service. So they need to have 3 days prior to the actual hearing of it. So what it would happen is it'd get listed on a chamber list. And then with the service, you then turn up on the day of the chamber list, and they will call over the chamber list and they'll sort out the order in which matters are going to be heard. And that can be determined by a lot of things. Some of them include the seniority of the barristers involved. So QCs tend to go first. Sometimes it's varied by the actual urgency of the matter. So if somebody's coming along with an ex parte urgent injunction, they will tend to skip and be at the head of the queue. So there's an argument about in the chamber court as to the order in which things happen. But this one is maybe not that urgent, unless the building is about to fall down, then certainly you would be looking at an ex parte application. But we're not told that. It says there's some cracks and that it's more about, apart from that, the loss of trade. So I would have thought 3 days notice should be enough. Okay, now what about the jurisdiction? Injunctions are based on a type of jurisdiction. Does anybody know what sort of jurisdiction?
Equity.
It's sort of born in equity, but it's
inherent jurisdiction.
It's inherent jurisdiction. That's right. So injunctions, and originally Anton Pillar orders and Morava, all of those things were born out of the inherent jurisdiction of the court. So all that means is that superior courts of record, of which the Supreme Courts are, have jurisdiction to over their own procedures in order to prevent abuse of process. So they see something like this potentially as being an abuse of process if there is no remedy to prevent this immediate harm, if you like. So that's the original source of injunctions, but then it's been captured. Well, the inherent jurisdiction still exists. So there is potential for the development of new types of remedies. So that hasn't gone. But the actual injunctions have been captured in both legislation and in the rules themselves. So where do we look? What legislation exists that says that there's the possibility of getting an injunction? Anybody know?
Civil Proceedings Act.
Yeah, it's the Civil Proceedings Act. So I'll just share this screen because I just want to show you something about how it's worded. It's a little bit bigger. Oh, just go down to here. There it is there. So Civil Proceedings Act 2011, Section 9. Now, it doesn't say the court has jurisdiction to hear an application for injunction. It doesn't say that. It says if a court has jurisdiction. And the reason why it says if a court is because it's based on the inherent jurisdiction, and that's superior courts of record. So note the language is different than you'll see in other provisions. So anyway, if a court has jurisdiction, which the Supreme Court does, to hear an application for an injunction, the court may, the word may, what does that tell you?
Discretion, right?
It's a discretion, as distinct from what word, which makes it mandatory?
Must.
Definite.
Must.
Must or shall is another way, but must. Okay. Now, and that says at any stage of a proceeding. Okay. So there has to be a proceeding. So you have to have an originating application to create the proceeding. By injunction, restrain, okay, then it has a bit dealing with contract we're not worried about, wrongful conduct, which Pedro would argue this demolition job that's going on next door is wrongful conduct because it's damaging his building and, you know, threatening his trade. And then you can see down further, the court may also at any stage of a proceeding grant an interlocutory injunction if it considers it just or convenient. So you'll see that terminology, just and convenient. So there's cases on what that means. So that's the legislative source of the power for an injunction, but there's also the inherent jurisdiction which faces that. Then you've got the rules. Okay, so you can see here, Rule 259, an application for a Part 2 order, so that's basically an injunction, should be served, but if a court is satisfied there is adequate reason for doing so, the court may grant the order without notice to the other party. So this is your ex parte in the absence of the other party injunction. Okay. Now we don't need an ex parte one here unless it's really, unless that cracking is so bad that the building's likely to come down. I think you could delay a few days. But you can see here that the court can have, if it wants, see it says may, with or without conditions, and it can actually grant the order for a limited period or until trial of the proceeding. Okay, so that trial of the proceeding would be for the ultimate claim, which in this case probably is for nuisance, and they would be, you know, seeking a remedy for that, and they may well be seeking some form of permanent injunction to be put in place as well.
So if you were to start a proceeding then like this, an originating proceeding to get the injunction.
An originating application. Yep.
Sorry?
It's an originating application. Yep.
Okay, and then you knew how much damage that he wanted to seek in compensation, and then you wanted to make a claim. Do you just redo your pleadings, or?
Well, yeah, you have to set out what you're seeking, which so you have a claim and a statement of claim. This remedy is to hold the position. Okay, it's all about essentially maintaining the status quo until the ultimate proceeding is determined. That's the role of this type of injunction.
Okay, and because your claim wouldn't be initiating, then you wouldn't need to do personal service. Is that correct? Of the pleadings for that?
Now with the, well, you have to have service of the originating application. Now, is that personal service?
Well, this would be personal service for this one, although it's an application, not a claim.
It's an originating application, and there are service rules. I'm just trying to remember what they are. Yeah, there it is. Okay, hang on. Yep. If it's an application, then it would just be ordinary service. So that's if there was an existing proceeding. If it's an originating application, I would have thought you would have to have personal service, because there's no other service that's occurred in relation to it. This is the beginning of it.
Sorry, but can you just redefine personal service? I mean, we all know what that means, but if there needs to be an application for a substituted service, then, you know, obviously the person's
it's the same. Yeah, you go down. It's exactly the same processes that we've talked about in earlier weeks. So,
Stephen, would Rule 105 assist a person?
What does 105 say? I haven't got.
Yeah, a person serving an originating process must serve it personally on the person intended to be served.
Well, it's certainly an originating process.
Mm.
So it would be personal service. I don't know if there's another rule. So 105 certainly seems to be what's required, but I wonder if there's another specific one in relation to originating application. I'm not sure. I'll just make a note. Make a note of that, as I will look that up.
Just in exact regards to that, if that person is specifically avoiding service on the original application, then you need to apply again to have substituted service,
Yes.
and that needs to go through the court process, etc.
Well, it's still an interlocutory application. It's still in the chamber court, so it's not
Exactly.
true. Yeah. So there's not a lot of delay associated with that. It's not as if you have to have a hearing, you know, months in advance.
No, there's generally not. It's actually quite a relatively quick process from
That's
my
right.
experience. Yeah.
Yeah, it's quick. So
But you still just have to go through the motions.
you do, and you have to, you know, incur the costs of it as well.
Unless you're self-representing. And that's
Well,
actually
yeah,
one of the
self-representing. There was actually, that's an interesting point. There was a High Court case in 2019 that if you happen to be a lawyer who's self-representing yourself, I'll put it that way, you're self-representing lawyer. It previously was the case that you were entitled to costs that for your time. The High Court threw that out in 2019. So lawyers are in exactly the same position as
lay people.
Mm-hmm. But both groups can actually claim disbursements. That's not, you know, the hourly rate of a solicitor or anything, but disbursements, things like, for example, if you paid for an expert report, but not for the lawyer's time, just as a side issue. Anyway, that just came to mind when you mentioned that. Okay,
sorry.
So
back to it. Sorry.
No, that's all right. I thought I'd just mention that while I'm going. It was good. So you have to have personal service of an originating application, just as you would with a claim. So that needs to occur, and it has to be 3 days that'll be 3 effectively clear days before the actual hearing of the interlocutory application.
Stephen, could I ask, for small matters like this, would the Supreme Court have jurisdiction for this? Because I couldn't imagine this being over $750,000 in damages. So how do you get an interlocutory in small claim?
The problem is that that requirement in relation to being a superior court of record. That's the issue.
How much is this injunction going to cost us?
Well, the actual claim, I keep emphasizing, there's 2 things here. There's the injunction to hold the position until the actual claim, all of that proceeds. So your claim is not going to be in the Supreme Court. It's going to be in a lower court. But your injunction, it has to be a court that's got jurisdiction to do that. And the Supreme Court certainly has.
So, Steve, may I just ask, when you speak of a superior court of record, you're referring to the appellate court, the Supreme Court, anything below?
Well, the generally no. The federal court, you could argue that they've got that as well. High Court, yeah.
But not district.
I don't think so. No.
I think they can handle equity though, can't they, the lower courts?
They can, aspects of it.
Maybe like an injunction?
Well, I'm not sure, to be honest with you. I'll have to check on that one, because most of these things I've always seen them in the Supreme Court. I'll have to have a look and see if I can find some examples to see if anything's happened in the district court, but generally Supreme. But the actual claim itself wouldn't be in the Supreme. It'll be in a lower court. So
when we speak of it being a court of record, I mean, I'm thinking
term. It's an historical term. Yeah.
So it's not me thinking that it publishes its judgments for me to read.
No, well,
it's something else.
No, it means court of record. It means it keeps records of what's happened. So it keeps records of its judgments. So it has a registry and it has a whole system behind it. I mean, this goes back centuries. It's not a new term. So, yeah.
Precedent would be a good term to use.
I have real trouble understanding you, Lindsay. I'm sorry. Say that again slowly.
Precedent would be a good term to use.
Precedent.
In terms of court records going back in time.
Well, there's certainly the precedent value of the court depends on how high it is in the hierarchy. But superior courts of record is a really old English concept. So if you're looking at it from an English perspective, it would be their courts of appeal. It would be their high court. It would, but just trying to think, it goes back such a long way. Just hang on one second. I'll just grab this dictionary over here and I'll just have a little look. Just see if it's got it in this old dictionary of mine. It might give us a term for it or a definition. May or may not. We'll just see.
Would it be something along the lines of the Magna Carta?
Hang on. CCP. Just seeing if it had it in it. No, it's not. No, it's unfortunate. No, it doesn't define it. Okay. So I will actually go back and put that into the study guide. So I'll find out the definition of what that is, but essentially it's an old term, it's an old English term. It means to prevent, it has the power to prevent abuse of its own process. And that was generally only in the very highest level courts. All right, okay, what is it? 625. We'll keep going. Okay, so the originating application is Form 5, because your application has to be in the approved form, and that's Form 5. It has to have some affidavits, a list of affidavits it's relying on. So you'd have to have an affidavit by, I think you'd probably get an affidavit by Pedro. You might want to get an affidavit by some sort of structural engineer, but certainly Pedro in relation to things like the dust, because he can say on oath what's occurred. Then you'd have to specify the orders sought. So what order would you be trying to achieve here? What's Pedro actually want initially?
Well, we want him to stop
He wants
cracking the walls of my restaurant, and secondly, kicking up his dust out of business hours.
That's right. So it'll be something along the lines of that Curl Up and Die be restrained from conducting renovation work on their beauty salon between the hours of 6 and 7 a.m. at least. That relates to, that rules out the evenings and right through the next morning. And these originating applications also required to specify the provision of the rules that you're relying on. So that's a little bit different from some of the other pleadings you've seen. So you could say you're relying on UCPR Rule 259. And then you might want to seek also the costs, that the defendant pay the costs of the plaintiff of the application, because you want to recover those. You've had to bring this application, it's costing you money. Why shouldn't Curl Up and Die have to pay for that? Because it was only because they're creating all this dust and demolition that's resulted in this application being brought. So then you would have the 2 affidavits as well, and that's about it.
Sorry, Stephen, just in terms of the health concerns here, obviously we all know what we're doing with COVID, but in this particular problem, we're looking at the latest flu outbreak. Where does Curl Up and Die or Pedro's restaurant stand on that front?
Sorry, can you just, what front was it again? Sorry, I'm really having trouble hearing you.
Sorry, I've put new headphones on tonight.
No, it's all right. It's just, maybe it's just me. I'm struggling.
No, it's if it's fading out, Lindsay.
Okay, is
Is
that
much
any
better? Yeah,
Okay,
better.
good. Just in terms of the what's mentioned here, the latest flu outbreak, where do Curl Up and Die and Pedro stand on that front? It is a health issue.
What do you mean? Because they're not getting customers, or?
We don't need to be talking about COVID here, but it's just what's written here.
Lindsay, I think that's just thrown in as a bit of context and not relevant to what we're actually, the application we're doing.
Fair enough, but if we're actually even talking about emergency procedures and things that are going on right now, then it may be relevant. But if we're just
but clients usually tell you 1,000 things, and
I do realize that, yes.
So, well, we don't know. If his restaurant is closed because we're all in lockdown, then they're not going to be doing any renovation work on it anyway.
Wouldn't think so, no.
So all of that will be sort of dead in the water. This is caused by, well, it's assuming a situation that the restaurant's still trading, so presumably it's legally doing that. So this is in a lockdown. So it only comes down to, some sort of assessment of what the damages are if this injunction is not granted.
So you're going
Okay,
to
so-
have to put a COVID clause into the lecture notes.
That's right. I know it's quite it's quite complicated to deal with the COVID situation because it keeps changing all the time, and the
And it
court,
depends on which state you're in too.
and it depends which state you're in, and it depends on all of these website changes on the Supreme Court site, and you know, and even procedures about how they're hearing things. They're trying to avoid having barristers and people gathering generally. So chambers, a lot of things. If you're in New South Wales, you'd be doing everything electronically. So yeah, there's been a lot of quite different approaches to handling this issue. But anyway, that's not really what our problem is tonight. Another aspect of this that comes to mind, if you're giving if you're seeking an injunction, normally you have to give an undertaking. Does anybody know what that undertaking is?
It'll be costs or securities that could be in favor of curl up and die in the event of this application being futile or an abusive process.
Okay, well, there's a couple of things there. It's not costs. It's not security for costs. That's a different concept altogether. But the undertaking for damage known as the usual undertaking as to damages is found in Rule 264. It actually tells you, it quite means an undertaking to pay to a person, whether or not a party to the proceeding, who is affected by the order, an amount the court decides should be paid for damages the person may sustain because of the order. So what potentially could that be for curl up and die? So if an order for an injunction is made, preventing them being able to renovate their salon,
There's going to be a loss of, there's going to be a delay in returning to operational capacity.
Exactly. So then you're looking at their loss of earnings.
There
So
could be
that
some
would,
losses from contract too with the tradies.
well, that's right. Of course, that's exactly right. There may well be losses associated with that as well. So that's Rule 264. So if you're seeking an injunction, you've got to be prepared to give, you've got to give that undertaking.
What about any loss of structural integrity to the building? We've got cracks in the walls.
Yeah. Well, it's cracks in Pedro's wall. Whether that's actually a shared wall between the two, we don't know. He might be in a building next door.
But if one building is causing cracks in another wall, then it would be prudent to assume, I suppose, that it would be impacting on both the structural integrity of both.
Well, we don't know
units.
what the nature of the renovation is in curl up and die's situation. Maybe they're demolishing the wall and rebuilding it. We don't know.
In which case you'd still need a whole different ballgame of injunctions and permits and everything else to allow them to pursue this renovation in the first place.
Well, there's a mixture of things going on there. Permits, that would be building permits in relation to what they're doing. That's separate from the injunction issue. The only aspect there where that sort of overlaps would be in relation to the undertaking as to damages if they're prevented from pursuing their renovation as quickly as they want to. Or if there's aspects of a positive aspect of the injunction might be that they actually have to conduct their renovation in such a way as it doesn't damage Pedro's building any further, or they also might have to repair his building. But anyway, there's a lot of assumptions and supposition about all of that. The basic idea is to try and prevent the loss that Pedro's incurring because of the dust and everything else, and the damage to his building, to prevent it getting any worse, or to at least maintain the current status quo, as it's often said, until there is actually a determination of the claim that would be connected with all of this.
Stephen?
Yeah.
Sorry. Would you be able to explain the process of starting a claim in the lower courts with the power of the Supreme Court? Hang
on. If the injunction is granted, if the injunction is granted by the Supreme Court, then there's an injunction in place. Then you can bring your claim in the other court. So they're separate proceedings.
So you move the claim down to, say, the magistrate's court, or if it's a small
claim. The claim. You're not moving it. You don't have a claim. It hasn't started yet. You would start it in the correct jurisdiction for the amount involved.
Okay.
Okay. Now we need to go back and look at a couple of things, and that's if you're seeking an injunction, then you have to actually establish two things. There has to be a serious question to be tried, and then that the balance of convenience favours the granting of the injunction. Those two things have to be established. So that balance of convenience you saw was actually written in one of those rules. There has to be a serious question to be tried. So what is the serious question to be tried in our particular matter here?
The curl up and die has caused damage to Pedro's building and premises.
There's that potential nuisance as well. I mean, there could be several claims associated with the facts. So there is a serious question to be tried. And the balance of convenience. So what does that mean, the balance of convenience?
Would it mean that, like, it's best to do this early before there's far more damage done?
Well, it would be, wouldn't it? Because that abates, that's reducing or abating the potential loss.
It's an even-handedness, isn't it? The presiding judge is going to consider the impact that the proposed order is going to cause on curl up and die.
That's right. That's right. They balance up the impact of this injunction on both sides. And if you look at it realistically, what have you got? You've got one party, curl up and die, who wants to renovate their salon. Okay. Then on the other hand, you've got Pedro, whose building's getting cracked and who's got dust and debris and everything else impacting on his business when he's trying to trade in the evening. So, I mean, my reaction to that, because this is a discretionary sort of thing, would be in favour of Pedro, would have thought, to maintain the status quo, protect the building, protect the trading of Pedro, if you like.
Protect the safety of the staff, their health and safety.
And the customers.
Yeah, exactly.
In the at least the short term, until the actual proceeding commences properly, or the parties come to a negotiated solution. But Pedro would want this injunction continued if it was ultimately something that they couldn't negotiate a solution through ADR or whatever process. But if they actually go through the court process, then Pedro would want to be protecting his building all the way through.
Now, would Pedro
seeking not an interim, but it would then be seeking a permanent injunction.
Would Pedro be then claiming costs in this entire matter?
Well, I think so, because you saw that we had a claim for costs as part of the originating application.
And his possibility for that, I would think personally that would be fairly reasonable.
Yeah, absolutely. You'd be seeking your costs in the whatever claim you ultimately, or in the statement of claim as well. Absolutely. All right. Now, originating applications have to be supported by evidence given by affidavit, not by oral evidence. So in the chamber court, you're not essentially bringing witnesses with you. It's not a trial. It's based on affidavits. Hearsay rules apply to evidence in affidavit form, but there's an exception for interlocutory proceedings. And that means that you can effectively tender evidence through your affidavit as long as the author of the affidavit, person, or in other words, the person making it, adduces the evidence of the source of it. So, for example, you may include in your affidavit an expert report from an engineer that says that these cracks in the building are being caused by the construction work happening at Curl Up and Die, because it would be better if, personally, I would have got the engineer to do an affidavit to that effect, but you can use Pedro or even the solicitor as long as they can adduce evidence of the source of the information. In other words, where the information has come from. So that's all permissible in these originating applications, the affidavits used to support them. The reason for all of that is it's designed to be a cheaper process, because if you have to start calling witnesses, it no longer is something that can generally fit within a chamber court, because usually the longest matters that a chamber court will hear would be up to about 2 hours. If it goes beyond 2 hours, they won't entertain it. So basically your interlocutory applications, or in this case an originating application, is going to be quite short. That's the whole idea of the chamber court, is for short, quick matters to be resolved. It's not a trial, so you don't expect to see any witnesses being called. All right, I think that is pretty much it. So I will check on a couple of things that come out of that problem, and I'll add them into the answer guide. So I will find out, I'll get a clear statement of the Superior Court of Record. I'll check that issue with the District Court, and also that Service Rule 105. I think that's the rule that applies, but I just want to make sure there's not another one lurking that deals specifically with this. All right, so I'll add that in. Problem 24. Now, problem 24 is another one of these problems where it's in the wrong court. But so the actual problem is Bookworm Limited is a manufacturer and distributor of Mills and Boon type romance novels, which it owns the copyright. Bookworm Limited becomes aware that Copydex Limited is making inferior copies of Bookworm's latest title, Love on the Rocks, and are selling them at a discounted price. Bookworm Limited issues a Supreme Court claim against Copydex, claiming infringement. So it's infringement of copyright. There's your problem, isn't it? Because where should that go? It's not the Supreme Court of Queensland, is it?
Federal court.
Should be in the federal court. That's right. So I put that in there just to make sure that you keep in mind these jurisdictional questions. But anyway, we'll assume that it can be in the Supreme Court for the purpose of the exercise, but just remember that it's a federal court matter. Okay, anyway, you told the claims validly served mid-August, defenders entered notice of intention to defend, okay, delivered its defence. October, the plaintiff obtained an interlocutory injunction restraining Copydex from selling any further copies of this allegedly infringing material until further order. You're instructed by the managing director of Bookworm, Mr. Worm, that he spoke on the phone to the managing director of Copydex, Mr. Xerox last week. Worm told Mr. Xerox that the company Bookworm's going to proceed to trial. Xerox then says, go for it, Worm. If you drag me into trial, I'll get rid of the stockpile of books for free. You'll be on rocks like that book. No, there's no case, no money, tough luck. Okay. You were further instructed by Mr. Worm that there's a former employee, Sally Prude, who has some illegal copies of this. Worm wants to get hold of these for $500, and then you're to advise Bookworm and Mr. Worm. You might think, well, that's an unrealistic situation, except that's actually happened. I had a case like that once, where somebody had actually, it was a textbook, they had photocopied it and they bound it up and were selling it in a shop. So, and one of the things you want to do is get evidence of these illegal copies. So you want to go and try and buy one. So I was sent out by a law firm when I was a very young article clerk many, many years ago to go and try and buy a copy of this illegal book. So, yeah, so these things do happen. Believe it or not, they do. So anyway, looking at this, okay, it's a federal court matter. So what we've got is threatened destruction of evidence, isn't it? So Xerox is threatening to destroy the evidence that you actually need to help you prove your claim for infringement of copyright.
If I can just very quickly start. Mills & Boons is actually a London-based company. They do have a division in Sydney, Harlequin Books, which is also a division of HarperCollins.
Mm-hmm.
And they, obviously Sydney in New South Wales. And yeah, obviously the issue is distribution of assets, but we've got 3 distinct jurisdictions right there. And in terms of the final claim, $500, that's Magistrates Court. Small fry.
Yeah, so where we've got a situation where there's a threatened destruction of evidence, what sort of remedy do you need to make sure that you can obtain those, in this case, books?
Need a freezing order.
Well, you need to be able to seize the documents and any other order, any other evidence, right? So it's actually a search order. It's an ex parte search order, or what was traditionally called an Anton Pillar. And it's ex parte because you don't want to warn the other side, because as soon as you warn the other side, they'll get rid of the evidence. So that's why it's done in the absence of the parties. So what's the difference between a search order and an interim preservation order, which is different? So what does an interim preservation order seek to do? Anybody know?
Does it stop the ability to deal with the assets, where the Anton Pillar you're allowed, well, not necessarily allowed to take, but can take the assets such as the books?
It's sort of nearly there. It's the interim preservation order is preserving the property. That's the subject of the action. Okay, it's preserving the property, and people have competing claims against that property. Whereas the search order, or the Anton Pillar order, is not so much about the property. It's about the evidence. It's about obtaining evidence for a different sort of claim. The claim is not for the actual photocopied books. The claim is for infringement of copyright. So if you were looking for an interim preservation order, that would be in relation to these illegal photocopied books that aren't worth anything. That's not what you're trying to do here. What you're trying to do here, there's no argument over the value of, or who owns these photocopied books. What the argument is about is trying to get evidence to support a claim for infringement of copyright. So you need a search order to get that evidence. Because the ownership of the property, these photocopied books, is not in dispute. Our client, Mr. Worm, doesn't really care about these photocopied books, but what he does care about is getting the evidence represented by a copy of one of those things, of one of these books, to show that there has been a breach of copyright, because that's where he's going to get his remedies, his damages for breach of copyright from. He doesn't want to obtain 500 copies of photocopies of a book. That's not what he's after. He's after monetary damages for breach of copyright. So that's why he would be seeking a search order.
So we're looking at IP rights, yeah?
Copyright. Yeah.
IP rights, yeah.
So the very existence of that photocopied book proves that there's been an infringement of copyright. And that's what will base your search order. So that's the first thing to note about this. The other piece of evidence we've got is this phone call, because that's also evidence that Worm can adduce that indicates that Xerox, Mr. Xerox, is specifically talking about destroying the books, destroying the evidence. So that's another reason why you want the search order, because it's authorizing the seizure of the documents and preventing the destruction of that evidence. That's the whole idea behind it. So where do we look for a search order? Which rule are we considering? Anybody know? 261A is the relevant rule. And it says the court may make an order, known as a search order, in any proceeding or in anticipation of any proceeding. So you don't actually need to have a proceeding on foot. It can just be in anticipation of it, for the purposes of securing or preserving evidence and requiring a respondent to permit persons to enter premises for the purposes of securing the preservation of the evidence which is or may be relevant to an issue in the proceeding or anticipated proceeding. Okay, what happens if you get the search order, you go out there to Mr. Xerox's Copydex Limited's premises and he refuses to let you in? You show him the order, but there's no way on earth he's letting you in.
You can't demand entry, but he would be in contempt of court.
That's right. He's potentially in contempt of court. You can't break in. You can't bust down the door and pounce on the books. It's just that there's potential for Mr. Xerox and Copydex Limited to be in contempt of a court order. There's Rule 261B sets out the requirements for the grant of a search order, so that the court may make, so it says may, so it's discretionary, may make an order if it has satisfied that the applicant has a strong prima facie case on an accrued cause of action. So in this case, it would be for breach of copyright, strong prima facie case. So that's where the evidence, so you have to have some sort of evidence acknowledging that these copies potentially exist at that location and that you've got the evidence of what Mr. Xerox has said on the phone, which is pretty good, isn't it? He's saying, you know, tough luck, I'm going to destroy these books. Well, that sort of acknowledges that they exist and that there's a potential he's going to destroy them, which is the second element, which is B, the potential or actual loss or damage to the applicant. The potential loss or actual damage to the applicant will be serious if the search order is not made. So it will be serious because the search order is not made. You can't get a copy of the book and it makes it more difficult to prove the infringement. So that can result in loss or damage because of the existence and sale of these books is leading to a loss in your revenue because you can't sell the real copies of the book. And C, there is sufficient evidence in relation to a respondent that the respondent possesses important evidentiary material, and there is a real possibility that the respondent might destroy the material or cause it to be unavailable for use in evidence in a proceeding or anticipated proceeding. So that's again where the telephone call is important. because there's a potential loss of the material, and there's a real possibility that it could be destroyed. So you've got all of the elements you need to get a search order. You can do this one a little bit differently. You can make it by an application or by an oral application. So you can actually do it orally in court. But typically there would be an application to do this. If there's a proceeding on foot, if there's no proceeding on foot, then you'd need an originating application to get it before the court. But it can be oral. So in theory, that's under Rule 32, in theory, you could seek an order of a judge. You could ring up and see whatever chamber judge is on duty and seek to make an oral application for this. But that would be pretty unusual. All right. Now, what about the books with Sally Prude? What's the problem there? Remember, Sally Prude is the ex-employee who just happens to have copies of these essentially illegal books and wants to sell them. What do you think about that situation? So Sally Prude worked for Mr. Xerox, but no longer does, but has some copies of these books and wants to, and Worm wants to buy them from her for $500.
So she's illegally taken these illegal books.
Essentially, potentially she's stolen them. She has stolen this, potentially anyway, we don't know for sure, but she's got copies of these books. If the implication is that she's actually removed them from the premises of copy decks without their authority, so she's in effect in receipt of what, or it's holding stolen goods.
So is she a bailiff or is she?
No, she's a former employee.
But she's holding the property, that's all. So she's like a bailiff, isn't she? Unless she stole them.
Not a bailiff, a bailee.
Bailee, that's right. Where
A
she's holding the property.
Yeah, sorry, you're throwing me there because a bailiff is a court officer.
That's right. It's
Okay,
getting late in the week. You know what
the
it's like.
No, it's been a long week. The bailiff is a person who can, you get to, you can use them for service. You can get them to even like a sheriff. They can go and sell things. Bailiffs they can be in courtrooms as security officers. Yes, that really threw me, that one. Bailiff. Bailey, I tend to think she's just got copies of these things she shouldn't have. She doesn't own. So would you advise your client to buy stolen property?
Sally has not necessarily illegally obtained them. Whether or not she should morally be withholding them from the rightful owner, that remains to be seen.
Well, we don't know, do we? That's the problem.
Exactly, yeah.
It's just a lot easier to do it properly and get a search order.
Yeah, or just return the goods to the rightful owner and be done with it, because she's claiming $500. Well, no, she's trying to sell them for $500, which is a minuscule amount, really. And yeah, just either give them back or
well, you can't get a search order against Sally because she's not a defendant.
No.
Wouldn't you have to be fairly careful in relation to, you don't know what her relationship to Xerox is. So if he was, Worm was trying to buy them from her, she might actually give Xerox the heads up and affect your application for a search order as one issue. And so if you were going to get someone to try and purchase those copies so that you could have them as evidence, then you'd have to get someone a little removed to do that.
Yeah, I'd be really concerned about buying the books off her. What about, if you think of her position, she's not a party at the moment in any sense of the word. you could get production by a non-party under Rule 420 as a potential. So if you look at that rule, it says this rule applies to the person named in the subpoena for production. So you could subpoena the production is not a party to the proceeding, unless court otherwise orders a subpoena to produce a document or thing must permit the person to produce the document or thing. So you could subpoena it, I suppose.
Could she be like an accessory to the crime, because copyright is a crime? So she could be an accessory. So maybe you can subpoena her that way.
Yeah, we don't know. We don't really know enough, do we? We don't know why she's got these copies. Yeah, I just think this whole issue about dealing with her is really fraught with danger. It's just so much more straightforward to.
Best left alone.
I really think it's best left alone. I just think it potentially is a real minefield dealing with her.
They may have been gifted by the original author, and this is now coming up because she's trying to unsell them, which is actually her right if they were gifted.
Yeah, we just don't know how she's got them or in what capacity she's holding them.
I think when we did evidence law, though, I don't think civil evidence is bound by the same rules as criminal. So the illegally obtained evidence rule, I don't think it's as strict in civil cases. I think that's what I remember being told.
It's certainly strict. No, that's true. It's certainly stricter in crime because, as I say, the liberty of the subject is at risk. The liberty of the accused. So the civil standards are lower. It's just like the standard of proof is lower in civil proceedings on the balance of probabilities as opposed to beyond reasonable doubt. So there's a difference in the standards. Yeah, my personal view would be not to do anything in relation to her and to pursue your remedy of a search order directly against Copydex and Xerox, Mr. Xerox, because you've got the evidence that you need to be able to get that order, and then you can execute it. And if they don't comply, then you can get them, they'll effectively be in breach of a breach of the court order, contempt of court.
Stephen, who does the search order? If you get a search order from the court, do you take that to the police? How is that actually?
No, you would do it. You would go out there and you would give them the order and seek to obtain a copy, take the evidence.
Okay.
I think what I read was that you had to have a third party solicitor that was prepared to supervise the attempted entry and all that.
Well, I suppose if you think about it in terms of if there's a dispute about whether they were given the actual order, if there was any sort of dispute about how it was actually executed, then having a third person who's independent puts you in a stronger position, as long as you've done everything correctly, because they can give evidence if called upon to to verify what's actually happened. You see a lot of tax cases where they execute these sorts of things, but I don't see why you can't execute it yourself. But if you want to have an independent person there, that's certainly an advantage, I suppose, but I'm sure it's necessary.
That's actually a very interesting question. To have a third party there, if you're personally serving somebody, then can that person take a photo to say those documents have been personally served on this person?
Well, I don't need to take a photo. I mean, they can just give evidence of what they've seen. If you start taking recordings of things, that opens up a whole other can of worms.
This is a whole world of kind of worms these days.
Yeah, the simplest proposition would be that they can give evidence of what they observed. So there isn't a recording of anything, but they can give oral evidence as to what happened.
But all that aside, if the other party has somebody else that comes along and said, well, no, that never happened, then where are you going from there? And we all know issues that have been had with services.
Well,
So,
it just comes down to whoever the judge believes in the circumstances.
best laid argument. Absolutely. Yeah.
Yes, that's right. All right. Where are we? 7:05. Okay, 7:05 already. That went quick. All right. Well, that was it. I'll add a few bits into this answer, I think, just on a couple of those issues that we raised tonight, so that we've got a clear statement of that before I post it up.
Stephen, for what it's worth, I just opened up the Westlaw platform. Has got an annotated copy of the Uniform Civil Procedure Rules, and at 105, meaning of originating process. Originating process means : a claim, an application, a notice of appeal, a notice of appeal subject to leave.
Right.
So that might
So that would certainly cover our situation.
cover, yeah,
Yeah.
for our application, yeah.
I was a bit wary about the UCPR because there's so many rules.
Yeah.
Trying to keep them all in your head, as you know, is a challenge. So, but that rule certainly applies. But whether there's something else lurking, I just want to double check, have a look around. But I think that rule is the one we need. But yeah, I will check anyway. So I'm very wary. The other thing I found, actually, I started updating the ADR chapter. Remember that of the book, the ADR chapter? And I came across a book. Which one was it? It might have been. No, it was a LexisNexis title on ADR, but it had a really good chapter on pleadings, which I wish I had discovered a few weeks back for you. But what I'll do is I will scan that, because we're allowed to scan one chapter out of a book, and I'll post it up for you, because it's got some examples of pleadings, and it has some good references in it too. It's just a shame that I hadn't done that earlier. I would have been able to give it to you for that assignment. It would have helped you, I think. Anyway, that's what happens.
Stephen, just out of personal curiosity, that case that you mentioned the other week about the denial of right to trial by jury in Victoria, do you happen to remember the name of that?
No, but
I was looking for it, and I've yet to be able.
It's a high court case.
I've looked there as well.
Trial by jury. Okay. Now that one wasn't a high court case. That was something else. Yeah, I'll find that one too, and I'll put up a general email. Yeah, I've got that. I've put that in. I've been updating the civil procedure book, because there'll be eventually a new edition. So I've been going through. I went through 320 Court of Appeal cases, and I picked up this. I think it was in Victoria. This one where because of COVID, then they didn't have the opportunity to have a jury. But I will find that. Yeah, I've got it in that chapter in the update. So I'll find it, and then I'll post it up on the unit site.
If you could, that would be fascinating.
Yep.
Thank you.
Yeah, no, it's an interesting question, because I've never seen that. It's very unusual for something like that to happen, but I suppose we're living in unusual times, aren't we?
We really are. And I'm actually in Victoria myself, so yeah.
Okay. All right,
really
I'll find
unusual.
that. Yep. I'll find that. It's not that I've got that written down somewhere. All right, we might leave it there. I've got a little bit of work to do, and then I'll post up everything for you. I'll see you next week.
Thank you very much. Have a good weekend.
Thanks.
Okay. Bye.